presentation is for Queensland medical consumers, patients and families, and considers whether negligence law truly protects them when a diagnosis is wrong, missed or delayed. A misdiagnosis occurs when a condition is incorrectly identified, not detected at all, or discovered too late for effective treatment. From a legal perspective, not every diagnostic error amounts to negligence. The law only intervenes when a doctor falls below the standard of a reasonable practitioner and that shortfall causes actual harm. In law, reasonable does not mean perfect or error-free. It means the standard expected of an ordinary competent practitioner with the same training and knowledge judged at the time of treatment, not in hindsight. Rogers Whittaker, 1992. As Stapleton notes, the law's focus on technical reasonableness rather than the patient's loss of opportunity can leave families uncompensated even when real harm has occurred. The scale of the problem is immense. Australian Institute of Health and Welfare figures estimate diagnostic error contributes to approximately 21,000 preventable hospital deaths annually, making it one of the leading causes of avoidable harm. Medical indemnity reports confirm its seriousness, showing diagnostic error accounts for nearly half of all negligence claims by value. Yet despite this, more than 70% of misdiagnosis claims in Queensland fail under the Civil Liability Act 2003. This contrast highlights the core problem for patients. While misdiagnosis is frequent and serious, the law sets narrow thresholds. Negligence requires showing what a reasonable doctor would have done. For families, this means that even harmful mistakes may not qualify as negligence if they are seen as within a range of reasonable professional responses. The law therefore recognises harm but often denies remedy, raising the question of whether it serves corrective justice. The doctor-patient relationship gives rise to a clear duty of care. In Rogers and Whittaker, the High Court emphasised that the law does not allow doctors themselves to set the standard. Instead, the courts determine what a reasonable practitioner would have done, ensuring that duties reflect patient needs rather than professional convenience. The court explained that reasonable care requires considerations of what risk a patient would regard as material, not merely what doctors usually disclose, at page 490. Hospitals also owe a non-delegible duty, recognised in Qantas and State Transport Authority, 1984, as a category where responsibility cannot be delegated. Mason and Justice stressed that hospitals bear a special responsibility to ensure safety regardless of delegation. This ensures that accountability extends to institutions, not just individual clinicians. Yet cases like Wallace and Cam 2013 reveal how courts limit this duty. The court held that liability only extends to the precise risk that the duty was intended to prevent. Even where a breach is proven, if the harm flows from a different risk, compensation is denied. For patients, this narrow approach creates confusion. They may prove that the duty was breached, but still walk away with nothing because courts classify the resulting harm as outside its scope. This shows how the meaning of duty in law is narrower than the public might expect. Section 9 of the Civil Liability Act 2003 Queensland defines when breach occurs. It requires that 1. The risk of harm is foreseeable, 2. The risk was not insignificant, and 3. In the circumstances, a reasonable person in the defendant's position would have taken precaution. Each phrase sets a different threshold. Not insignificant sets a higher bar than the pre-CLA standard, but still captures risks that are more than trivial, as confirmed in Berry and Wyong Shire Council 2005. The reasonable person test requires balancing the probability and seriousness of harm against the burden of taking precautions, section 9 subsection 2, often referred to as the Shirk calculus. But reasonable does not mean eliminating all risk. Lex's commentary on the reasonable person principle explains that negligence law requires reasonableness, not perfection. In Sanchez, Sidriopoulos and Canavan 2015, the court confirmed that foreseeability does not require banning ordinary activities, an important lesson for medical practice where uncertainty and differential diagnosis are common. For doctors, this means that even low probability risk may require action if the consequences are grave and the precaution is simple. Naxaxis and Western General Hospital, a pre-CLA case from 1999, illustrates this point. Although the chance of intracranial bleeding was rare, a CT scan should have been ordered for a schoolboy with head trauma because the harm was catastrophic and the precaution straightforward. By contrast, more recent Queensland cases show courts applying Section 9 restrictively. In Van Ham in Central Queensland Hospital, 2018, a GP's failure to refer a patient with bowel symptoms was excused because early signs were described as non-specific. Likewise, in Lees and Ipswich Hospital 2017, delayed recognition of spinal infection was excused because symptoms resembled benign conditions. For families, this demonstrates how courts interpret reasonable generously in favour of doctors, often narrowing the patient's chance of success. Plaintiffs also face a heavy evidentiary burden. Although the civil standard remains the balance of probabilities, courts stress that serious allegations require clear and convincing proof. Bringshaw and Bringshaw, 1938, established this principle, and in practice, it places significant reliance on expert testimony to show what a reasonable doctor would have done. Academic commentary highlights that breach is not about whether a test was ordered, but also whether patients were warned about diagnostic uncertainty and advised when to seek urgent review. Carver and Smith, 2021, describes this as a dual duty: competence in testing and honesty in communication. Queensland decisions have so far concentrated on technical judgment, leaving this communicative dimension underdeveloped. This gap weakens patient autonomy and increases the risk of diagnostic delay. Section 22 of the Civil Liability Act protects doctors from liability where their conduct aligns with professional opinion accepted by a significant number of respected practitioners, unless that opinion is irrational. The problem is the Act never defines significant. In Mules and Ferguson, the Court of Appeal held that unanimity is unnecessary. Even a sizable minority view can shield a practitioner. For patients, this creates uncertainty. A diagnostic shortcut that is still followed by a group of doctors may be excused in court, even when many others consider it unsafe. The law therefore risks equating professional frequency with professional reasonableness. The only statutory safeguard is in Section 22, subsection 2, which allows courts to reject peer opinion that is irrational. This reflects the reasoning in Bolitho and City and Hackney Health Authority, 1998, where the House of Lords held that professional practices must withstand logical scrutiny. Yet Australian courts rarely apply this safeguard robustly. In State of Queensland and Mason 2020, the High Court confirmed that peer evidence should be respected unless it is manifestly illogical. Courts are understandably reluctant to brand respected medical opinion as irrational, meaning patients face an almost impossible evidentiary hurdle. If enough doctors endorse a practice, even one inconsistent with clinical guidelines, it may be legally defensible. In practice, this requires producing counter-experts willing to testify against their colleagues, relying on authoritative guidelines and demonstrating that the practice has no rational foundation. This is expensive, time-consuming, and hampered by professional solidarity, which often discourages criticism of colleagues. From the case of Chelavupa and Selvedran, many claims fail not because negligence cannot be shown, but because patients cannot secure sufficient expert testimony to satisfy the court, from the journal Mahar and Burke. These critiques underlie that Section 22 tilts the balance of negligence law heavily in favour of professional practice. Now we turn to causation. Section 11 of the Civil Liability Act sets the rules. It tells us that negligence must be a necessary condition of the harm. The classic but-for question: would the harm still have happened if the doctor had acted properly? Then it asks under subsection 1b whether it is appropriate for responsibility to extend to that harm. Subsection 2 makes the but-for test the default, and subsection 3 only lets courts step away from it in very rare cases, such as where multiple factors combine to cause the injury. Section 12 further reinforces this difficulty by placing the entire onus of proving both factual causation and scope squarely on the plaintiff, meaning families must carry their full evidentiary burden even when negligence is clear. Now, on paper that looks tidy, but for patients it creates a very narrow doorway. The High Court in Strong and Woolworths 2012 confirmed that plaintiffs must show on the balance of probabilities that harm would not have happened without the negligence. In a misdiagnosis case, that means proving that earlier tests or referral would probably, not possibly, have changed the outcome. The problem is stark. In Tabet and Gett 2010, a child's chance of avoiding brain damage fell from 40% to nothing because of a delayed diagnosis. Yet the court said no legal loss had occurred because the odds had never been over 50%. Families hear this and ask, how can a real opportunity be destroyed and yet count for nothing? The law's answer is probability rules and possibility is invisible. As Crennan Justice at page 111, quote, the destruction of a possibility of a better outcome, even a substantial possibility, does not constitute compensable damage. This illustrates how the law draws a rigid line at 50%, even though medicine operates in probabilities. Melissa Meldrum suggests a more balanced approach, proportionate damages, so that if a 40% chance is destroyed, compensation reflects that value rather than being denied entirely. Weller et al. 2024 extends this critique, arguing that the exclusion of lost chances not only denies justice to patients, but also undermines systematic accountability, because negligence without remedy reduces incentives for cultural and institutional change. Things get tighter again under subsection 1b. In South-Western Sydney Local Hospital District in Gold 2018, involving delayed treatment of an infection, the Court of Appeal insisted that liability only extends to the kind of harm the duty was meant to guard against. For patients, this kind of reasoning can mean that even where negligence is clear, courts refuse to connect it to the harm suffered because they classify the consequences as outside the duty's scope. Families are left asking why the duty is recognised in principle but denied in practice. Earlier authority such as Vera and the Water Board 1998 reflects this reasoning, refusing to extend liability to complications categorised as beyond the scope of the original duty. The evidentiary burden imposed by Section 12 magnifies these difficulties. Plaintiffs must marshal detailed expert evidence to reconstruct what would have happened if diagnosis had come earlier, a costly technical and speculative exercise that few families can sustain. Courts, meanwhile, are reluctant to accept anything less than a 51% likelihood, which excludes genuine but less than probable opportunities for recovery. For Queensland families, these rules mean that even when negligence is clear, recovery is often out of reach. They face courts that demand near certainty, judges that resist hindsight, and laws that reduce real opportunities to nothing. The effect is that causation, instead of protecting patients, too often protects professionals, leaving families with recognition in words but no remedy in practice. Diagnosis is delayed or missed. Patients seldom experience it as the failing of a single practitioner. From their perspective, the harm often arises out of a chain of missteps. While doctors undoubtedly owe a personal duty of care, hospitals and health services also carry a non-negligible duty to ensure that their systems are reasonably safe. From the case of Condis and State Authority in 1984. Although Condis arose in the employment context, the principle applies equally to hospitals. Institution cannot avoid liability for systematic failures by pointing to the negligence of individuals. In Wolverson and Todman 2015, the Queensland Court of Appeal made clear that the inquiry was not limited to the conduct of the individual clinician. It extended to record keeping and communication systems that shape the diagnostic process. This is significant. Liability can attach not only to what a doctor does or fails to do, but to the institutional scaffolding within which that decision takes place, from the case of Ellis and Wilson District Hospital 1989. For plaintiffs, deciding who to sue is therefore more than a technical question. Framing a claim against a hospital allows attention to be placed on systematic negligence. As Fiona McDonald from the Health Law Australia 4th edition has argued, patients tend to experience harm as a systematic breakdown rather than a single misjudgment. Oliver Quick from the book Regulating Patient Safety, published in 2017, adds that institutions are better placed to spread losses and reinvest in safety improvement. Ian Frackleton from Medical Malpractice 2013 likewise warns that focusing liability only on doctors risks scapegoating individuals while leaving the underlying structural causes intact. The law of damages reinforces this dynamic. Under the Law Reform Act, Queensland, joint and several liability applies in personal injury. This rule means that where both a doctor and a hospital are found liable, the plaintiff may recover the full damages award from either one. The defendants then resolve contributions between themselves. From the patient's perspective, this is crucial. Even if a hospital's systematic failings are accounted for only part of the outcome, joint liability allows for full recovery and ensures they are not left undercompensated. For doctors, it prevents them from being left to shoulder blame for institutional weaknesses. Hospitals, it creates a strong incentive to maintain safe systems since they may bear the entire cost of a judgment if individual clinicians cannot. Recent commentary by Barbara McDonald, 2022, Chapter 12, Torts in Australia, stresses that this deep pocket function of institutional liability is not just about compensation, but about prevention. By allocating risk to hospital, the law channels resources towards system-wide safety improvements. Negligent misdiagnosis is not an abstract legal problem. For Queensland families, it determines whether the health system protects them or leaves them to carry the cost. Yet Sections 9, 22, and 11 of the Civil Liability Act form a triple lock. Risks are dismissed as not significant, unsafe practices are excused by peer opinion, and destroyed chances are treated as nothing. The result is recognition without remedy. Until reform occurs, negligence law in Queensland will continue to validate harm in words but deny justice in practice.